Please be seated. The sitting is open. Before we start our judicial proceedings today, I would first like to express, on behalf of the court, our deepest sympathy to the Japanese people who have had to face the devastating impact of last week's earthquake and subsequent tsunami. It is with particular sorrow that I have seen the images of utter destruction caused in my homeland by this natural calamity and learned of the appalling loss of life, with over 20,000 fatalities and missing people. It is a cruel and shocking death toll. The court extends its heartfelt condolences to the families of the victim and to the people and government of Japan. We place our sincere hope in the success of the recovery efforts and the resilience of the Japanese people in finding a way to overcome this terrifying ordeal. I would like to invite you to stand and observe a minute's silence in memory of the many earthquake victims. Thank you. Please be seated. The court now needs to hear the oral argument of the parties in the case concerning application of the Interim Accord of the 13th September 1995, the former Yugoslav Republic of Macedonia versus Greece. I note initially that Judge Skotnikov, for reasons made known to me, is unable to take his seat on the bench today. I further note that since the court does not include upon the bench a judge of the nationality of either of the parties, both parties have availed themselves of the right under Article 31, paragraph 2 of the statute to choose a judge ad hoc. The former Yugoslav Republic of Macedonia chose Mr. Budislav Vukas and Greece Mr. Emanuel Lukunas. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his power impartially and conscientiously. Pursuant to Article 31, paragraph 6 of the statute, that same provision applies to judges ad hoc. Notwithstanding that Mr. Vukas is currently serving as a judge ad hoc in another case and has made a solemn declaration for the purposes of those proceedings, Article 8, paragraph 3 of the Rules of Court provides that he must make a further solemn declaration in the present case. In accordance with custom, I shall first say a few words about the career and qualifications of each judge ad hoc before inviting him to make his solemn declaration. Mr. Budislav Vukas, of Croatian nationality, was professor of public international law at the University of Zagreb from 1977 until 2008. He has held numerous other teaching positions around the world, including at the universities of Boston, Paris, Rome, Split, and Tilburg, and has also taught a course at the Hague Academy of International Law. Mr. Vukas has represented his government on various occasions, including in the 6th Committee of the United Nations General Assembly, at the 3rd United Nations Conference on the Law of the Sea, and at the World Conference on Human Rights in Vienna. Mr. Vukas has combined his academic and diplomatic achievements with a career as an international judge. He was a member of the International Tribunal for the Law of the Sea during almost a decade, and as such, its vice president from 2002 until 2005. He is currently judge ad hoc before the court in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Croatia versus Serbia and Montenegro. He is also a member of the Court of Conciliation and Arbitration within the Organization for Security and Cooperation in Europe. Mr. Vukas is further a member of numerous academic institutions, including the Croatian Society of International Law and the Institut de Droit International. In addition, he has published numerous works and articles on different aspects of public international law, particularly in the field of the law of the sea, environmental law, and international human rights law. Mr. Emmanuel Roukounnas, of Greek nationality, is Honorary Professor of International Law at Athens University, where he has taught since 1970. He has given lectures at numerous other academic institutions around the world, including at the universities of Thessaloniki, Paris, London, San Sebastian, Berkeley, and Yale. Mr. Roukounnas has also taught a course at the Hague Academy of International Law. He is a former member of the International Law Commission and is a member of the Institut de Droit International and a member of the Permanent Court of Arbitration. In addition, Mr. Roukounnas has served as a member of the United Nations Committee for the Elimination of Racial Discrimination, as a member of the group of experts on the Conference on Security and Cooperation in Europe for the Balkans, and as a member of various committees within the Council of Europe. Mr. Roukounnas has represented his government on a number of occasions, including as delegates at the General Assembly from 1980 to 1999, and as part of the Greek delegation at a number of international diplomatic conferences. He has appeared before this court as counsel to the Greek government in the Aegean Sea continental shelf, Greece versus Turkey case. Mr. Roukounnas has published numerous works and articles in diverse fields of international law, ranging from the law of the sea, human rights and humanitarian law, to bioethics and European unification. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Mr. Roukounnas to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Mr. Roukounnas.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
Thank you. I shall now invite Mr. Vukas to make the solemn declaration prescribed by the statute. Mr. Vukas.
Solennellement que je remplirai mes devoirs et exercerai mes attributions de juge en tout honneur et dévouement, en pleine et parfaite impartialité et en toute conscience.
Thank you. Please be seated. I take note of the solemn declarations made by Mr. Rukunas and Mr. Vukas and declare them duly installed as judges ad hoc in the case concerning application of the Interim Accord of the 13th September 1995, the former Yugoslav Republic of Macedonia versus Greece. I shall now recall the principal steps of the procedure so far followed in this case. On the 17th of November 2008, the government of the former Yugoslav Republic of Macedonia filed in the registry of the court an application instituting proceedings against the government of Greece, contending that Greece has acted in violation of its legal obligations under Article 11, Paragraph 1 of the Interim Accord signed by the parties on the 13th of September 1995 and which entered into force on the 13th of October 1995. In its application, the former Yugoslav Republic of Macedonia, referring to Article 36, Paragraph 1 of the statute, relied on Article 21, Paragraph 2 of the Interim Accord to found the jurisdiction of the court. By an order dated the 20th January 2009, the court fixed 20th July 2009 and 20th January 2010, respectively, as the time limits for the filing of the memorial of the former Yugoslav Republic of Macedonia and the counter-memorial of Greece. The memorial of the former Yugoslav Republic of Macedonia was duly filed within the time limit so prescribed. By a letter dated the 5th of August 2009, Greece stated that, in its view, and I quote, "The court manifestly lacks jurisdiction to rule on the claims of the applicant in this case," end of quotation, but informed the court that rather than raising preliminary objections under Article 79 of the Rules of Court, it would be addressing issues of jurisdiction together with those on the merits. The counter-memorial of Greece, which addressed issues relating to jurisdiction and admissibility, as well as to the merits of the case, was duly filed within the time limit prescribed by the court in its order of the 20th January 2009. At a meeting held by the President of the Court with the representatives of the parties on the 9th of March 2010, the co-agent of the former Yugoslav Republic of Macedonia indicated that his government wished to be able to respond to the counter-memorial of Greece, including the objections to jurisdiction and admissibility contained therein, by means of a reply. At the same meeting, the agent of Greece stated that her government had no objection to the granting of this request, insofar as Greece could in turn submit a rejoinder. By an order of the 12th of March 2010, the court authorized the submission of a reply by the former Yugoslav Republic of Macedonia and a rejoinder by Greece, and fixed the 9th of June 2010 and 27th of October 2010 as the respective time limits for the filing of those pleadings. The reply and the rejoinder were duly filed within the time limits so prescribed. Having ascertained the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of the rules, that copies of the pleadings and the documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, in accordance with the court's practice, the pleadings without their annexes will be put on the court's website from today. I note the presence at the hearing of the agents, counsel, and advocates of both parties. In accordance with the arrangements on the organization of the procedure which have been decided by the court, the hearing will comprise the first and second round of oral arguments. The first round of oral arguments will begin today and will close on Friday, the 25th March 2011. For the purposes of today's sitting, due to the length of the opening speech, additional time will be allocated to the former Yugoslav Republic of Macedonia after 6 p.m. as needed. The second round of oral arguments will begin on Monday, the 28th March 2011, and will close on Wednesday, the 30th March 2011. The former Yugoslav Republic of Macedonia, which is the applicant in the case, will be heard first. I now give the floor to His Excellency, Mr. Antonio Milosevski, agent of the former Yugoslav Republic of Macedonia.
Distinguished President, first allow me myself, on behalf of my government, to associate with the condolences and the sympathies that you have presented for the people of Japan. All our countries will give its contribution to support in this strategy. Distinguished President, distinguished members of the Court, my government is exceptionally honored to appear for the first time before this Court, the principal judicial organ of the United Nations, which serves as the paramount guardian of the international justice. At the outset, I hope you might allow me to express my deepest respect to the members of the Court, availing myself of this opportunity also to congratulate Professor Emanuel Rukunas and Professor Budislav Vukas for their appointments as ad hoc judges in this case. I should also like to express my appreciation to you, Mr. President, and members of the Court, for the flexibility you have shown in scheduling this hearing. We are fully aware of the Court's caseload and the time constraints that you are dealing with. If you allow me, Mr. President, members of the Court, at the very outset of this case, I would like to pay my respect and express my profound appreciation to the late Professor Thomas Frank. He appeared before you on a number of occasions with a great distinction, and he also served as an ad hoc judge. He was an invaluable part of our legal team, and in the very last days of his life, we were privileged and honored to draw inspiration from his sharp thought, iron logic, and noble spirit. Mr. President, since winning its independence peacefully in 1991, 20 years ago, the Republic of Macedonia has been committed to peace, the rule of law, respect for human rights, and peaceful resolution of international disputes. We are a multi-ethnic democracy pursuing a policy of good neighborliness and regional cooperation. We have joined the international community in its efforts to bring lasting peace, stability, and prosperity in the Balkans, and in integrating the Balkans into the European Union and North Atlantic Treaty Organization. Indeed, at key moments during the last two turbulent decades in the Balkans, my country has been an important part of the solution, not part of the problem. In the early 90s, during the breakup of the former Yugoslavia, we were fully aware of the danger of an armed conflict spreading to our country, so that as early as 1992, upon our request, we hosted the first preventive deployment mission in United Nations history. This mission, aptly titled the United Nations Preventive Deployment Force, or UNPREDEP, help stabilize our security situation. Further, through the 1990s, we built a multi-ethnic society, developing a strong system for protection of human and minority rights. In 2001, when my country faced severe internal crisis, it was the maturity of the Macedonian citizens and the moderation of our leaders, supported by the European Union, the North Atlantic Treaty Organization, and the other international actors that brought about political solution to this crisis. The conclusion and implementation of the Ohrid Framework Agreement, along with NATO and EU-oriented reforms, additionally contributed to my country's role as an active provider of security. In the spirit of the good neighborly relations, my country has regulated its borders with all our neighbors in a peaceful way, respecting international law. Today we participate in several peace missions in other countries. For example, we participate in the European Union's Althea mission in Bosnia and Herzegovina, charged with implementing the Dayton Agreement. We participate in the International Security Assistance Force, ISAF mission, in Afghanistan, working closely with the North Atlantic Treaty Organization. For nearly 2 years, our military medical staff in Afghanistan has had a joint mission with our Greek colleagues. Given our constructive policies and performances at home, but also abroad, we had been well on track to be invited to join NATO at Summit in Bucharest 2008, together with Croatia and Albania. Mr. President, the Republic of Macedonia has a strong interest in and continues to develop friendly relations with all countries, including the Hellenic Republic, the respondent in this case. Regretfully, our bilateral relations are burdened with the unfortunate issue of the difference over the name of my country. Though resolution of this issue is not before the court in this case, let me provide you some background. The respondent raised concerns about my country's name following our peaceful proclamation of independence in 1991. This difference caused a serious delays in the process of international recognition by other states, in the integration of my country into United Nations and other international organizations, and in the development of our relations with the respondent. The Greek-Macedonian dialogue on the difference over the name started in 1993. Since then, we have actively engaged in good faith negotiations with the respondent under the auspices of the United Nations in an effort to resolve that difference. We regretted that in 1994, our neighbor decided to introduce a unilateral embargo on trade and transit of goods between our countries, and sought to obstruct international recognition by other states and impede our membership in international organizations. It was the Interim Accord that both parties signed September 13, 1995, that created the legal basis for normalization of relations between our two countries. Today, after more than 15 years, we can say that in general, the Interim Accord has worked successfully. It has largely enabled both parties to put behind them period of tension and to open a new chapter of bilateral cooperation and providing an impetus to good neighborly relations and understanding. In particular, the Interim Accord contributed to the removal of the respondent's economic embargo, and for a period of 13 years, removed an impediment to our successful integration in the international community, allowing us to join international organizations such as the Organization for Security and Cooperation in Europe and the Council of Europe. In recent years of negotiations, as previously, the parties and the personal envoy of the United Nations Secretary General, Mr. Matthew Nimitz, have tabled various proposals which have been accepted as a basis for a solution or rejected by the one or the other party. In October 2005, we accepted a proposal by Mr. Nimitz which, according to his correspondence to both parties, meets the minimum requirements of both sides and thus should be the basis of an honorable and acceptable solution. Previously, the same year, the respondent accepted a different proposal by Mr. Nimitz. In March 2008, immediately before the NATO summit in Bucharest, my country accepted a proposal by Mr. Nimitz, and we expressed the readiness to put it for a vote before the Macedonian citizens on a referendum. Unfortunately, the proposal was rejected by the respondent. Instead, and in contravention of the Interim Accord, the respondent resorted to objecting to the extension of an invitation to my country to join NATO. In the period from November 2009, the Greek-Macedonian dialogue concerning the name difference has continued in parallel with high-level leadership meetings between the two countries. As recently as last month, Ambassador Nimitz commended both countries in the ongoing name negotiations, stating, I quote, "Both sides expressed a positive attitude towards moving forward on this issue. I think the biggest development of the last year has been the dialogue of the two prime ministers, 8 meetings between them. In my view, this has had a positive effect, starting to build trust and understanding at the highest levels." End of quotation. Mr. President, members of the Court, I convey that information simply as background for your understanding of the present situation. Contrary to what the respondent may say, in this case before you, we do not seek that resolution of the name difference, either directly or indirectly. This is and remains the object of the mediation process under the auspices of the United Nations. What do we seek in bringing this case? This case has been brought to ensure that the respondent uphold one of its key obligations under the 1995 Interim Accord. Nothing more and nothing less. Our application concerns the respondent's violation of one aspect of the provisional regime established under the Accord, an obligation that has enabled the normalization of bilateral relations pending resolution of the name difference. Specifically, our application concerns the respondent's obligation under Article 11, Paragraph 1 of the Interim Accord, which had been respected for nearly 13 years following the entry into force of that agreement. By its conduct in the period leading up to and at the Bucharest summit in April 2008, the respondent violated Article 11, Paragraph 1 by objecting to our accession to NATO, even though it was clear and not in dispute that we were to be provisionally referred to in that organization as the, quote, former Yugoslav Republic of Macedonia, unquote. Indeed, that is the reference by which we are known in our contribution to NATO's efforts in Afghanistan since 2002. Yet, in 2007 and 2008, the respondent reverted to its pre-1995 practice, bringing to an end our ability to join international organizations of which the respondent is already a member. We very much regret this action and hope that the Court will assist the parties in returning to the system that was envisaged by the Interim Accord. This would enable us to continue to pursue membership in NATO and the European Union, a goal that we have had since 1993, and this is of tremendous importance for the internal stability of the Macedonian multi-ethnic democracy. The European and Euro-Atlantic integration has and will contribute to the stability in the region. Mr. President and members of the Court, this is a simple and narrow case of pacta sunt servanda. For a reason not permitted under the Interim Accord, the respondent objected to our membership in NATO. The respondent seeks to present this case as a complex one and advances a series of strained or irrelevant assertions, as well as novel legal and factual assertions that were not raised before April 2008. Its arguments appear to be designed to obfuscate what is rather straightforward violation of a straightforward obligation in the Interim Accord. In its pleadings, the respondent pursues four central arguments. First, the respondent insists that it may object if my country uses its constitutional name when communicating with international organizations or other countries, or even when other countries use the name of my country. The Interim Accord, however, allows no objection on that basis. In any event, there are no facts supporting that basis as a true reason for the respondent's objection. Indeed, the respondent goes so far as to claim that the reference, quote, former Yugoslav Republic of Macedonia, unquote, is the provisional name of my country and that there is an obligation erga omnes for its use, including by my country. Yet, such a claim is fully contradicted by the text of the Security Council Resolution 817 from 1993 and the statement of those who drafted that resolution. Such a claim is also contrary to the long-time understanding of this resolution as applied in the practice of the United Nations, of other international organizations, and of third states. This understanding was even confirmed by Mr. Nimitz himself upon the conclusion of the Interim Accord in 1995. We note that the Hellenic Republic itself has agreed to accept official correspondence from the Republic of Macedonia in one of the bilateral agreements concluded to put into effect the Interim Accord. Second, the respondent attempts to justify its breach by creating the impression that there have been violations of the Interim Accord on our side. This is a false assertion, to which we have responded in our pleadings. Yet more importantly, it is an argument concocted ex post facto. At no point before April 2008 did the respondent inform us that it considered us to have been in material breach with the Interim Accord, and that it intended to suspend in whole or in part the Interim Accord. Nor did it inform us that it intended to pursue countermeasures if any alleged breaches on our part were not remedied. In this way, the respondent seeks to sidestep the law of treaties and the law of state responsibility and to replace one stable system of treaty relations with rights unilaterally accorded and determined. Third, the respondent repeatedly mischaracterizes our claim by insisting that this case is about NATO's conduct, over which the court has no jurisdiction. Let me be clear. We are not asking the court to issue any declaration or order in respect of NATO or any other international organization. We ask only for an assessment of the actions of the respondent undertaken at the time when NATO was deciding on the extension of an invitation for membership to my country. We ask for a declaration that the acts of the respondent represent a violation of its obligation under Article 11, Paragraph 1, together with an order that the respondent must in the future abide by this obligation in respect to our accession to NATO, to the European Union, and to other international organizations of which the respondent is a member, so long as we are to be referred to in such organizations as provided in the Security Council Resolution 817. Fourth, the respondent seeks to justify its breach of Article 11 by pointing to a different article of the Interim Accord, Article 22, which the respondent says allows it to object when exercising rights under the North Atlantic Treaty. While I will leave the legal arguments in this respect to our legal counsel, allow me to make one observation. If one accepts this reasoning, which is contrary to the plain meaning of the provision, Article 22 would completely eviscerate Article 11, denying to my country one of the central reasons why it agreed to the Interim Accord. By granting the relief sought in our application, the Court will reaffirm the fundamental principle of pacta sunt servanda and ensure respect for the provisions of the Interim Accord. Our stability and our ability to secure membership of international organizations must not be instrument for the respondent to impose his preferred solution for overcoming the name difference. This is exactly what the Article 11 of the Interim Accord was meant to prevent, and it did prevent for 13 years. Mr. President, our decision to institute proceedings with the Court was not an easy one, nor was it taken without serious considerations. However, we were left no other choices. We followed the path that the respondent should have taken. If it truly believed that we were in material breach of the Interim Accord, it could have instituted proceedings against us under Article 21 of the Interim Accord, or invoke the procedures provided by 1969 Vienna Convention on the Law of Treaties, or the proceedings envisaged under the rules applying countermeasures. It did none of these things. Instead, it took the matters into its own hands and acted outside the law. By contrast, we have followed the prescripts of the Interim Accord and initiated these proceedings. When the parties concluded the Interim Accord, they agreed on the jurisdiction of the Court to settle issues deriving from the Accord, with the exception of the name difference itself. The applicant asks the Court to hold the respondent to its obligation under this extremely important bilateral instrument, concluded exactly for the purpose of ensuring the legal framework for development of good neighborly relations. I am pleased now, Mr. President, to let you know how the case will proceed. I will be followed to the bar by Professor Philip Sands, who will deal with a number of legal and factual matters predating the actions of April 2008. Professor Sean Murphy will then address the NATO membership process and the events leading up to and including April 2008 and the respondent's objection to our membership of NATO. Professor Pierre Klein will then deal with the first part of our arguments, explaining why the respondent is wrong to assert that the Court lacks jurisdiction and that our claim is inadmissible, an argument he will conclude tomorrow morning. Following on from there, we will address in detail the circumstances in which the respondent has violated Article 11, paragraph 1 of the Interim Accord. We will then conclude the morning with submission on why the respondent's violation of Article 11, paragraph 1 cannot be excused by the law of treaties or the law of state responsibility or any other newly embraced rules or principles of international law. We will also address the remedies that we seek. Finally, we will bring our presentation to an end with some brief concluding remarks. I take the opportunity to express my thanks to Ms. Bline Nigralich for her important contribution. She expresses her regret for being absent this week due to personal family reasons. Mr. President, members of the Court, it is truly a privilege for me and for my country on the occasion of its first appearance being here in this Court. I will remain available to provide such assistance to you as you may need from us throughout these proceedings. And now I invite you to call on Professor Sands. Thank you for your attention.
I thank His Excellency Mr. Antonio Miroshovsky, agent of the former Yugoslav Republic of Macedonia, for his opening statement. Now I invite Professor Philip Sands to take the floor.
Good afternoon, Mr. President, members of this Court. On the first day of spring, I'm privileged to appear before you on behalf of the applicant in this important case. Whilst the issues in the case may be discrete, the stakes are high. The case is about holding the respondent to its treaty obligations under a bilateral treaty so that it is no longer allowed to object the applicant's entry into NATO and other international organizations. The case is of evident significance for the country's internal stability and also for regional well-being. This Court, of course, has extensive knowledge about the Balkans region and by its judgments has contributed to the processes of reconciliation and renewal that underpin future development and stability. At the heart of the Court's approach, there has always been the recognition that stability and respect for treaties are closely connected. The 1995 Interim Accord has played a key role in providing conditions of stability between the applicant and the respondent. For 13 years, until the respondent's actions leading up to April 2008, the Interim Accord has functioned without difficulty. There was no claim by the respondent to the applicant that it was in material breach of any of the obligations imposed by the Interim Accord. And so my task this afternoon is to provide a brief overview of the period from the applicant's emergence as a state in 1991 to the conclusion of the Interim Accord in 1995. And I'm going to focus in particular on the circumstances that led to the adoption of the Interim Accord, on the deal that it reflected, on its objectives and terms, and in the manner in which it functioned between 1995 and the period that will then be taken over by my colleague, Professor Sean Murphy. Before I turn to these matters, I hope you might allow me, Mr. President, if I just take a single moment to express my own personal deep regret and sadness that Professor Thomas Frank is not with us today. His professional contribution to our preparation was very far-reaching, but beyond that, I owe Tom the greatest debt of personal gratitude for his constant support and friendship to me over many years, benefiting from a desire that many of you yourself recognized to foster the development of new generations from every continent and for inspiring us in the vital significance of principle and integrity in the face of a troubled and very cruel world. His beloved partner Martin Daly continues to follow the case from New York, and to him, through you, I express the condolence of our entire team, our deep sense of sadness, and also our very great appreciation to him for his support. Mr. President, in August 1944, the Macedonian people proclaimed their state as Democratic Macedonia. In 1946, the state became the People's Republic of Macedonia. And in 1946, it became one of the 6 constituent republics of the Federal People's Republic of Yugoslavia. From 1963 to 1991, it was the Socialist Republic of Macedonia. Then, on 25th of January 1991, the applicant adopted a declaration of sovereignty. On the 7th of June of that year, the applicant's parliament changed the constitutional name to the Republic of Macedonia, Republica Macedonia. And on the 25th of September 1991, following a referendum, the parliament adopted a declaration of independence of the Republic of Macedonia, and on the 17th of November 1991, a new constitution. Over 5 decades, 50 or more years, the applicant's name elicited no objection from the respondent. And we note that in its opinion number 6 of the 14th of January 1992, the Badinter Committee expressed the view, and I quote, that the use of the name Macedonia did not imply any territorial claim against the respondent. What was true in 1992 is evidently also true today in 2011. That said, the difference between the applicant and the respondent as to the name is not before this court. This case is about the respondent's objection to the applicant's membership of NATO in blatant violation of a bilateral treaty. From late 1991 until 1993, following the applicant's declaration of independence, increasing numbers of states recognized the applicant's statehood. In July 1992, the applicant applied for membership of the United Nations. Regrettably, because the respondent objected to the applicant's constitutional name, it lobbied United Nations members not to support admission. Faced with the necessity of enabling the applicant's admission in the United Nations, a compromise solution was developed. And on the 7th of April 1993, the Security Council adopted Resolution 817. You can see that now in relevant part on the screen, Mr. President and members of the Court. And you will find it, together with all the other materials that will show on the screen during today and tomorrow, also in your Judges folder, tab 2. Mr. President, Resolution 817 recommended membership of the United Nations on the basis of the applicant, and I quote, being provisionally referred to for all purposes within the United Nations as the former Yugoslav Republic of Macedonia, pending settlement of the difference that has arisen over the name of the state, end of quote. And the following day, with the adoption of UN General Assembly Resolution 47/225, the applicant was admitted to UN membership. Now, a central aspect of the respondent's arguments in this case is whether the applicant is itself required to use that provisional reference in communications with the United Nations, with NATO, and with other international organizations, or whether the Resolution 817 compromise, which is also reflected in the Interim Accord, allows it to call itself by its constitutional name, the Republic of Macedonia. In that regard, it must be noted that Resolution 817 did not require the applicant to call itself by the provisional reference of the former Yugoslav Republic of Macedonia. Indeed, it has never called itself in that way, and that has raised no difficulties whatsoever with the United Nations Secretariat or with any other United Nations organ. The applicant has always used its constitutional name in written and oral communications with the United Nations, its members and officials, and the same has been the case in all other international organizations. Nor did, for the avoidance of doubt, Resolution 817, on its face or otherwise, require any other state to refer to the applicant by the provisional reference. Now, this understanding was recognized by participants in the 1993 decision-making process that resulted in the adoption of Resolution 817. It was led by a troika comprising of France, Spain, and the United Kingdom. In our reply, for example, we referred to a statement prepared by Ambassador Jeremy Greenstock, who was involved in the drafting of Resolution 817. He states that the provisional designation, and I quote, meant, for example, that the nameplate and all official UN documents would refer to the member only by that name until such time as the difference over the name had been resolved. End of quote. However, he continues, this did not mean that the new member was required to refer to itself orally or in writing by that provisional designation. It was, as I recall, informally recognised that the new member would be likely to continue to refer to itself by its own constitutional name, the Republic of Macedonia. Similarly, it was understood that any third state might also refer to the new United Nations member as it considered appropriate, whether by the country's own preferred name or by the agreed provisional reference that was determined by UN Security Council Resolution 817. Now, the respondent has made no effort whatsoever in its pleadings to challenge the veracity of Ambassador Greenstock's statement that is before you in evidence. What he does is merely to complain that Mr. Greenstock's statement was not made contemporaneously. Has the respondent introduced any evidence whatsoever, other than its own statements to promote a contrary view to that expressed by Ambassador Greenstock? No, Mr. President, it has not. Nor has the respondent sought to rebut the statement made in similar terms by Mr. Matthew Nimitz, to which we drew the court's attention in our reply. Now, given what the respondent had to say about the lack of contemporaneity of Ambassador Greenstock's statement, the respondent's silence on this is rather curious. Mr. Nimitz's statement was made in September 1995, at the very time that the Interim Accord was adopted. Mr. Nimitz isn't just anybody. At the time, he was the special envoy of the United States to the negotiations on the Interim Accord, and he was therefore intimately involved in the negotiations and deeply knowledgeable about what was involved. Today, he's the special representative of the United Nations Secretary General on the name difference between the parties. So it's rather difficult to imagine a more authoritative or independent voice on this issue. So let's look at what he said in 1995, and I quote, "The people from the applicant's country, when they talk about themselves, use their constitutional name, Republic of Macedonia. And we have found this to be the case, that there is no requirement for them to use a name that they don't accept. But that doesn't mean that the organisation accepts the name." End of quote. Now, the respondent's silence on this evidence is very telling. Mr. President, our point is a very simple one. Whilst organisations to which the applicant becomes a member are required to refer to it by provisional designation, the applicant is entirely free to call itself as it wishes, as are other states, as a great many of them do. If the applicant wishes to call itself the Republic of South Australia in honour of a professor who might occasionally aspire to such a presidency, it is perfectly entitled to do so. If it wishes to call itself by its constitutional name, there's nothing in Resolution 817 or in the Interim Accord to prevent itself from doing so. To the contrary, such a practice is entirely consistent with and preserved and authorised by paragraph 2 of United Nations Security Council Resolution 817. Now, curiously, the approach outlined by Mr. Nimitz is one that the respondent itself accepted and signed off on in writing. A month after the Interim Accord was signed, on the 13th of October 1995, the parties adopted two memoranda, one on practical measures and the other related to the Interim Accord and the establishment of liaison officers. These memoranda and the practical measures explicitly confirmed that the applicant reserved the right to call itself by its constitutional name and that the respondent did not object to it doing so. So allow me now to turn to the conclusion of the Interim Accord, the treaty that lies at the heart of this case, a case that is squarely about pacta sunt servanda and the need to ensure respect for the law of treaties. Having read the respondents' written pleadings, you really could be excused for concluding that this is a really difficult and complex case that raises a multitude of factual and interconnecting legal issues. It is not. It is a very straightforward case about respect for a treaty. Our distinguished friends and colleagues on the other side of the room have had to embrace complexity. Why? The fog they have sought to create is, in this case, their only hope. Yet the court is bound to have noticed, even at this stage of the dispute, how much the respondent's case has changed. The arguments made in April 2008 have just disappeared in the face of the rather obvious difficulties that they raise when confronted with the text of the Interim Accord. Indeed, it cannot be said that the respondents were unaware of the implications of the Interim Accord back in 2007 and 2008, or its deeply constraining consequences. Rather helpfully, in October 2007, the respondents' embassy in Washington put out a press release containing an interview between a Greek journalist and Mrs. Dora Bakoyannis, the respondent's then foreign minister, and you will be able to find the entire text at Annex 73 of our memorial. The journalist asks Ms. Bakoyannis why doesn't her government just adopt the painless solution to invoke the Interim Accord and consent to accession to NATO under the name FYROM. Did Mrs. Bakoyannis say that the Interim Accord was not pertinent? No, she did not. Did she say that the actions of objecting to NATO membership were permitted by the Interim Accord? No, she did not. What she said was, and I quote, "Politically painless solutions are not in the national interest. Hiding one's head in the sand always has a cost, as does political cowardice," end of quote. So there you have it. There you have it, Mr. President. A clear admission on the part of the respondent that it knew about its legal obligations and that it simply chose to ignore them to avoid a charge of political cowardice. Did the respondent assert to the applicant at that time that it was in material breach of the Interim Accord? No, it did not. That's a new ex post facto claim, a claim of material breach that was made to the applicant only after the objection by the respondent at NATO, and then only as a response to our side characterising the NATO objection as a material breach of the Accord. And then, as these proceedings got underway, all the new arguments came tumbling out, magically no doubt, as new lawyers joined the team, and there's quite a few of them. In the face of the evident chronological and juridical weaknesses, the argument on material breach gave way to another new argument. This time, we got the sight of the exceptio. And then came an entirely new doctrine in international law concerning the right of immediate and unilateral action for special stopgap treaties. And then, that's not good enough, yet another new argument in relation to Article 22. And then having said in their counter-memorial that they're not going to argue countermeasures, what do they do in their rejoinder? They argue countermeasures. Now, Mr. President, I ask our distinguished friends, with the greatest respect, what was your case in April 2008? What is your case today? And I might also ask, given the ever-changing arguments on that side of the room, what's your case going to be on Thursday? And then what's your case going to be next Wednesday? Resolution 817 opened the door to the applicant's membership of other United Nations bodies and agencies, but the respondent continued to object to the applicant's constitutional name and just took matters into its own hands. In February 1994, it imposed a comprehensive embargo on trade. That dealt a serious blow to the applicant's already weak economy. And then it moved to object to the applicant's membership of important international organisations, of which the respondent was a member. Against this background, Lord Owen and Mr. Cyrus Vance began the process of bringing the parties into agreement on the way forward under the auspices of the United Nations. Now, initially, the process sought to resolve the name difference itself. But as that proved difficult, the process shifted to an agreement to resolve key issues on an interim basis. For present purpose, the central point that I want to make to you is this. The evolving drafts that became the Interim Accord had as a core objective ensuring that the applicant could join any international organisation provided that it followed the approach required by the United Nations in Resolution 817. In those circumstances, the respondent will be prohibited as a matter of law so as to force, for example, a resolution of the difference as to the name to object or to threaten to object. Until the Interim Accord, the respondent was under no specific legal obligation not to make any such objection. After the conclusion of the Interim Accord, however, any right to object was severely limited, and Professor Murphy will say more about this in due course. Now, you can find the Interim Accord at tab 1 of your folders. It is widely recognised as a singular diplomatic and legal achievement of the mid-1990s. The Court, as I've mentioned already, is acutely aware of the great and many difficulties that were faced in the Balkans between 1991 and 1995. Wisely, very wisely, the applicant and the respondent adopted another route. We might call it the rule of law route. They negotiated and on the 13th of September 1995 adopted a treaty. It entered into force a month later, and it's now been in force for 16 years. Neither party has ever taken any steps to suspend the treaty in whole or in part, or to seek to withdraw. Indeed, at no point before the Bucharest summit of April 2008 did the respondent assert to the applicant that it had acted in material breach. And that's an important point in this case, because both states are bound by the rules expressed in the 1969 Vienna Convention on the Law of Treaties, and thereby well aware of the detailed procedural steps and other rules they must follow if they wish to raise concerns about the other party's alleged action in relation to the Interim Accord. The law of treaties establishes a complete regime. Yet, the respondent is now asking the court, asking you to legislate new rules for this treaty and for its actions. And that's what this case is really about, whether the respondent can avoid the requirement of the law of treaties. And in our view, if the court accedes to the respondent's invitation to rewrite the law of treaties, it risks doing grave damage to the stability of the international system. And we're going to say more about that tomorrow. In the meantime, it's appropriate to consider the Interim Accord briefly and in the round. The Accord was largely drawn from a draft treaty proposed by Cyrus Vance and Lord Owen in May 1993 in an effort to normalise relations between the two states. The draft was forwarded by the United Nations Secretary-General to the Security Council, and it served as the basis for the negotiation of the 1995 Interim Accord. The 1993 draft and the 1995 Accord share a common structure and elements, and we've described this in detail in the memorial. The 1993 draft treaty was divided into 6 sections, sections A to F, each of which was adopted without change in the final text, subject to one exception. In the 1993 draft, section C, relating to the applicant's organisational and institutional membership, had been entitled European Institutions, but the parties eventually agreed that the section should cover all international, multilateral and regional institutions. Now, the Interim Accord, as adopted, comprises a preamble and 23 articles divided into 6 sections. Section A addresses friendly relations and confidence-building measures. It consists of 8 articles addressing matters such as diplomatic relations, the inviolability of the existing frontier, and respect for sovereignty and territorial integrity, and political independence. The section also includes the agreement in Article 5 to continue negotiations under the auspices of the Secretary-General of the United Nations on the applicant's name, and the commitments in Article 7 to prohibit certain activities or propaganda and avoid the use of a particular symbol. And it creates, for that purpose, specific procedures to address concerns relating to that article. Section B then addresses human and cultural rights, and it provides for respect for human rights and for the rule of law by reference to 8 international instruments, including the United Nations Charter, as well as the encouragement of contact between the parties. As I've just noted, Section C relates to international, multilateral and regional institutions, and it consists of a single provision, Article 11. That provision lies at the heart of this dispute. The fact that this obligation merits a specific section is not without significance, as Professor Murphy will explain. Section D comprises 3 articles that are intended to normalise the treaty relations between the parties, including both bilateral and multilateral arrangements. And Section E then addresses economic, commercial, environmental and legal relations, comprising 6 articles intended to enhance cooperation between the 2 states. Section F then contains some final clauses addressing the settlement of disputes. Article 21 provides for the jurisdiction of this court, the Accord's effect on third states and international organisations, Article 22, to which we will refer in due course, and the Accord's entry into force. The object and purpose of the Interim Accord is readily apparent from these provisions. It was intended to provide for the immediate normalisation of relations between the applicant and the respondent, and this is an objective that it achieved. It was also to provide for future cooperation, notwithstanding the continuing difference concerning the applicant's name, an objective that was also achieved over the next 13 years. In particular, having regard to the mutual interest of the parties in the maintenance of international peace and security, reflected in the preamble of the Accord, it provided for the recognition of the applicant by the respondent, for the establishment of diplomatic relations, for the adoption of practical measures, for a commitment to the free movement of persons and goods, including requiring the lifting of the economic embargo that had still been maintained by the respondent, and, significantly, the confirmation of the existing frontier between the parties as an enduring international border. The Accord reaffirmed the applicant's lack of territorial claims against the respondent and provided for the applicant to join the family of nations and to become an active member of the international community. In short, the adoption of the Accord confirmed that the respondent recognised the applicant's commitment to the purposes and principles of the United Nations Charter, to the promotion of democracy, to individual liberty and the rule of law, and to stability in relations between the 2 countries. And that, Mr. President and members of the Court, is why the Accord includes right at its heart the binding and clear commitment in Article 11, by which the applicant would be able to join regional and global international organisations, notwithstanding the difference over the name. Against this background, there are certain points of agreement between the parties. They may be obvious, but they're not without significance. The parties agree that the Interim Accord is a treaty. They agree that the Interim Accord, as such, is governed by the law of treaties, as reflected in the 1969 Vienna Convention, to which they are both parties. And they agree that from 1995 until the beginning of 2008, the Interim Accord operated without any particular difficulties. as I've mentioned, at no point before April 2008 did the respondent invoke any rights under the law of treaties to challenge the applicant's performance of its obligations under the Interim Accord. The evidence before you on the record is absolutely clear on that point. They also agree that the respondent had withdrawn all of its objections and had ceased to make any further objections to the applicant's membership in any of the organisations and institutions the applicant was then able to join between 1995 and 2008. So Article 11 has worked very well. Since 1995, the applicant has joined a great number of international organisations, beginning with the Council of Europe in November 1995 until most recently the European Patent Office a couple of years ago, without facing any objection on the part of the respondent. In 1995, following the adoption of the Interim Accord, the applicant was even offered and accepted membership of NATO's Partnership for Peace programme under the provisional reference provided for by Resolution 817. And in 1999, the applicant was invited and accepted to participate in the NATO Membership Action Plan, the MAP, also under the provisional reference. The applicant's military forces have since participated in numerous NATO exercises and contributed to a number of NATO campaigns, including the NATO-led Kosovo Force, KFOR mission. The applicant has contributed to the NATO-led operation in Afghanistan since 2002 and currently has approximately 170 personnel operating under NATO command, coincidentally a significant number more than the respondent. Throughout this period, the applicant was referred to by the organisation in the manner provided by Resolution 817, but it called itself by its constitutional name. Did this cause any difficulties? It did not. On the screen you can see an image that shows clearly an ISAF officer giving an award to a soldier on whose outfit one can read the word Macedonia. The uniform does not have an insignia with the words the former Yugoslav Republic of Macedonia, nor does it say party of the second part, nor does it say applicant. It says Macedonia. If there'd been a difficulty, one would assume that the ISAF officer who's to be seen in the photograph would not be engaging in the friendly act with which he seems to be engaging. Did the respondent raise concerns about the applicant's contributions to NATO? It did not. Did it raise concerns about the manner in which the applicant was referred to within NATO? It did not. So the curiosity is good enough for Macedonian men and women to risk losing their lives in Afghanistan, but the country is not entitled to join the organisation. Now, that's not to say that there were never any issues. A few years back, for example, at an end-of-year party in Kabul, Afghanistan, contributing forces to the ISAF were invited to bring a national dish. I understand that the applicant's offering was presented as Macedonian moussaka. This did not garner universal Hellenic appreciation. Gastronomic matters aside, and I for one can certainly attest to the delights of a good Macedonian moussaka served with a decent Greek salad and a good bottle of Retsina, perhaps even a 2008 Rhythinitinis Nobilis produced by the excellent Gaia winery on Santorini. Never once did the respondent raise with the application any formal allegation of material breach of the Interim Accord for putting Macedonia on its uniforms, or indeed in relation to any other matter whatsoever. There is no evidence before the court to the contrary. Nothing. These are facts, not the subject of disagreement. Yet since April 2008, the parties have disagreed about how the Interim Accord is to be interpreted, and these differences arise from the respondent's conduct leading up to the Bucharest summit in April 2008, as set out in Chapter 2 of the memorial and reply. To justify its conduct, the respondent has identified 4 principal lines of argument, as we're able to work them out, relating to the Interim Accord, around which it has woven its legal case. First, the respondent says the objection was permissible under Article 11 because it anticipated that at some point in the future, the applicant would use its constitutional name in communications with NATO. And Professor Murphy is going to address this in greater detail tomorrow, but for present purposes, let me simply note that in the period between 1995 and April 2008, the respondent never, not once, asserted that such practice by the applicant was wrongful so as to justify an objection by the respondent under the Interim Accord as a violation of the treaty. In its application to join NATO, the applicant made clear that it would follow the same practice in NATO as it has followed in every other organisation it has joined since 1995. There is no dispute as to that fact, as Professor Murphy will explain. Second, the respondent claims that the accord is a synallagmatic agreement, so that the fulfilment of the Article 11 obligation not to object to the applicant's membership of NATO is somehow linked to the applicant's fulfilment of each and every other obligation under the accord. Now, according to the respondent, the consequence of this is that it, the respondent, is perfectly entitled to decide unilaterally, without giving any notice and avoiding all of the constraints imposed by the law of treaties, that it's not going to give effect to the Article 11 obligation because of a purported violation by the applicant of some other part of the agreement. Now, this, as you will recognise, is a novel argument, and it suffers from a key difficulty. Putting aside the question of whether this is a synallagmatic agreement or not, of the kind identified by the respondent, on which we make no concession whatsoever, the respondent has not been able to find a single authority from this court, or indeed from any other international court or tribunal, that supports the novel argument on which it now relies. And the court, of course, will recognise that if accepted, the argument would just drive a coach and horses through the law of treaties. It's a regime that provides for stability and predictability, and it would be replaced with a system of unilateral acts adopted without notice by reference to no objective criteria. And we made all of these points in our reply, making clear why we don't accept that the Interim Accord is a synallagmatic agreement in the way proposed by the respondent, or that the obligation under Article 11.1 of the Accord is somehow conditional upon fulfilment by each and every other obligation it's being met. But even if Article 11.1 or the interim agreement as a whole were to be regarded as synallagmatic, what would be the consequences of such a finding? Let's take their case at the highest. Well, let's consider what was said by the Special Rapporteur of the International Law Commission in his second report on state responsibility in 1999. This is what he said. The Special Rapporteur is firmly of the view that the justification for non-compliance with synallagmatic obligations should be resolved A, by the law relating to the suspension or termination of those obligations, which is sufficient to deal with most problems of treaty obligations, and B, by the law of countermeasures, end of quote. Now, that view, which in our submission is perfectly correct, did not find disfavour with the International Law Commission at that time, as a number of individuals present in the Great Hall today will be well aware. In other words, if there is a violation of a synallagmatic obligation, this doesn't lead to some sort of specialised legal regime. It just leads you to the standard rules that arise with respect to either breach of treaty or countermeasures, the latter of which the respondent had said in its counter-memorial it did not seek to invoke in this case. The respondent had nothing to say about this statement, by the Special Rapporteur in its rejoinder. Again, it's a big and notable silence. Far be it from me to refer to my good friend Professor Crawford as an elephant, but it is the elephant in the room. And we look forward very much to hearing from Council for the respondent on this point later in this week. And we particularly look forward to hearing who, on behalf of the respondent, might be willing to stand at this bar and say that the Special Rapporteur just got it wrong. Nothing has changed in law or practice since his self-evidently correct view was set out. And that's why we assume the synagmatic argument has been reduced to just a small number of pages in the rejoinder and no longer really seems to be at the heart of the respondent's case. Frankly, it's hopeless. The respondent's third argument on the character of the Interim Accord is that it's merely a, as it puts it, and I quote, a provisional protective framework, end of quote. So the respondent puts this rather creatively. How can I put it? It's a stopgap treaty. It's a holding operation. And somehow from this they segue into the argument that this gives the Article 11 obligation a totally different, more conditional character. So we searched and looked high and far in the Vienna Convention on the Law of Treaties, the entire text, every article, every line, for the section that deals with stopgap treaties. We looked for the special rule on which the respondent seems to rely to be able to act entirely as it wishes when it wishes. This is what the respondent calls the right of immediate action. Once it has decided to characterise the Accord as falling within this particular category of international legal instruments. Now, this argument is as hopeless as the previous one, as every student of international law who is in this room, this great hall today, will immediately recognise. It is entirely without merit. It is unsupported by any authority whatsoever, a characteristic feature of the respondent's written pleadings. It's not immediately apparent to us what more remains to be said about the doctrine of immediate unilateral action for stopgap treaties. For the British among us, it reminds one of Monty Python and the dead parrot of issues. It is a dead argument, it is not a stunned argument, it is not a sleeping argument, it is a dead argument. The respondent's fourth treaty argument is that the meaning and effect of Article 11 has to be read in the context of Article 22. According to the respondent, while it was barred from objecting to the applicant's membership of an international organisation under Article 11, somehow it was nevertheless entitled to object to the applicant's membership under Article 22 due to purported rights or obligations arising under the constituent instrument of that organisation. Now, this claim is going to be addressed by Professor Klein later, and we're going to return to it tomorrow. For the time being, we simply invite you to ask yourself this question. In the context of its desire to join international organisations, and having regard to the practice that was followed over the next 13 years, why on earth would the applicant have agreed to a provision that would, on the respondent's approach, deprive Article 11 of any practical meaning and effect? You give with one hand and you take back with the other. It just makes no sense. It is nonsensical. Mr. President, this short submission sets out the context of the adoption of the Interim Accord. It is intended to provide you with a roadmap to the arguments that lie ahead. And you're going to pick and find a theme running through our presentations. And it's this. Against a background of facts that are clear, that are unambiguous, and that are hardly in dispute, the task for the court becomes an essentially legal one, namely to interpret and apply the Interim Accord by reference to those pertinent facts and the system of international rules within which it finds itself and to which this court has contributed so significantly. It will be clear to all that the respondent's position is one of constant flux, in which a totally evolving set of new and novel legal arguments, sometimes based on facts that don't even exist and aren't in the record, is brought to bear in support of a totally unjustifiable action. But the simple point is this. If you take yourselves back to 2007 and 2008, and you look at the facts in evidence, at the record that is before this court in 2 rounds of pleadings, we invite you to ask yourself 2 questions. First, what did the respondent do in 2007 and 2008? What did the respondent do? And second, when it was doing it, what did it say was the reason for its actions? Why? Those 2 simple questions lie at the heart of this straightforward case, and to assist the court in answering them, perhaps after a short break, Mr. President, I'd ask you to invite Professor Murphy to the bar. I thank you very much for your kind attention.
I thank Professor Philip Sands for his presentation. Before I invite Professor Sean Murphy to the floor, I think it's the appropriate moment to have a short coffee break for 15 minutes. Thank you.